Lord, I've agreed with Ms. Coulter, but I'd just like to mention the Lord Justice Phillips's point.
Yes, I think that's a very convenient way of doing it.
My position is that I do have an answer, but I'd still like further time to think about it.
Yes.
So I don't know whether your lordships and my lady would like me to.
No. Well,
Wait.
let me just think about this. I'm not anxious to promote large-scale exchanges of documents after the hearing.
Yeah.
If you feel comfortable doing so, if you want to just tell us the answer without seeking to persuade us of it,
Yes.
then if Ms. Coulter wants to tell us her answer without seeking to persuade us of that in writing, but it's probably helpful if you ventilate
Yes.
what you say the point is, just so it's present when we're all here, rather than us relying on documents.
Yes. No. I was going to suggest that if I have something further to put in, I do it by next Tuesday, and Miss Coulter has an opportunity to respond.
Well,
Is
so
that-
as
is
long
that
as Ms.
all
Coulter
right?
has an opportunity to respond, then
Yes.
yes. So tell us.
Could you take up bundle the supplementary bundle divider 17? Page 248. Page 248 is the first email that my clients received from the fraudster. And the bottom half of 248 is the text of a genuine email from Siam to Logix. And one can see that the email says that it's from Michael Goffstein at siamaero.com, which is Siam Aero's real email address. And then the fraudster adds the piece at the top. Dear Remy, kindly check below, mail and advise. Thanks a lot and sorry for the inconvenience once again. And you can see that that comes from Michael Goffstein at siamaero.co, which is the fraudster's email address. And then 247 over the
Before we
page.
leave this, I'm interested in what's at the top of that page. I mean, maybe it's too, in a sense, it's too vague to act as a genuine alert to anybody.
Yes.
And I don't know whether this rubric appears in relation to messages going in the other direction. But it appears that something in the bowels of the system is registering that something has happened with these.
Yes.
With these handles.
Yes. That is correct.
Anyhow, that wasn't why you took us to 248.
Yeah. Negligence isn't a point that's been raised by either side in this case so far. I just showed you that because it shows what happened, and then the two over the page at 247 is the first email from my clients to the fraudster, which is what Lord Justice Phillips was referring to. Hi, Mike. And he sent it to the fraudster at Logix. Sorry, it doesn't say who he sent it to, but this is his email to the fraudster. Hi, Mike. This is great news. Can you please amend the contract with LRU and new price? And without arguing it, my submission would be that that's not a breach of contract because it's not information or documents. And then And then the last piece in the jigsaw, if I can call it that, is page 185, which is one of the enlargements. I don't know how your lordship can conveniently look at that. Page 185. The bottom.
Sorry, I'm so sorry. I'm
Sorry.
lagging behind you. Just following up.
I was just looking at 247. Does your lordship have that?
No, I'm sorry. I'm just looking at something else.
Sorry.
Sorry, I'm sorry to delay you. Yes, there seem to be about half a dozen of those automatically generated messages throughout the exchanges. Anyhow, where had you got to now?
I was going to look at 247.
247.
Which is 247 is the reply from Remy Chris to the fraudster.
Yes.
In which she says, "Hi Mike, this is great news. Can you please amend the contract with LRU and new price?"
Mm-hmm.
And my point on that is that I say it's not doesn't contain sufficient information to be a breach of contract. I'm not going to argue it. And then, just to complete it, page 185, which is one of the documents that the court asked to be enlarged. And on 185, you can see in the middle, in blue, 31st of July, Remy Chris at logixaero.co, which is the fraudster, sends on Remy Chris's email. "Hi Mike, this is great news. Can you please amend the contract with LRU and new price?"
Mm-hmm.
And the only other thing to notice about that, though I don't think anything turns on it, is that the fraudster has deleted his chaser message. Kindly check below mail and advise, because if he put that in, then Sam would have known there was something wrong, because they never said that. And then what happens after that is that, as one can see from the top half of 185, Siam Aero respond to it by sending the two draft SPAs. So we would say that the first breach of contract is in fact by Siam. That's one point. My second point, very quick, is that even if there was, even if 247 was a breach of contract, it doesn't satisfy the but-for test, because that would imply that if my clients hadn't sent that, the fraudster would just have gone away. That's not something that's been explored, and in my submission it's extremely unlikely. He would have tried something else on one of the parties. We don't know which. My lords, that's all I was going to say about that point.
Thank you. Well, can we leave it on this basis that I mean, I think we have the general point is you've taken us to various emails which you say don't contain anything that is information.
Yes.
It's just communication, as it were, not information. Is that applying to all of your materials, or just the ones you've taken us to?
Just the one that I've taken you to, because that was I was simply answering my Lord Justice Nichols' point about which was that the first email to the fraudster was our email. That was a breach of contract, and that caused everything.
Right.
Circularity.
Right.
I'm not saying we didn't send any emails in the course of this that were breaches of contract, but that one wasn't.
Right. Okay. Well, subject to anything that arises in Ms. Coulter's submissions, we'll treat those as being your submissions, and of course anything you answer in relation to that. Can we return to this question before we rise at the end of today to see whether you are going to have to put pen to paper or not? Because I don't encourage it unless you wish to do so.
Well, I'm going to have to put pen to paper anyway, because there are various things that I've said I'd refer the court to. One of them was the authorities on
Yes.
the common sense test, and the other was for other authorities on this kind of fraud. I will do anyway.
Right. Well, let's have an understanding before we rise today
Yes.
as to what, if anything, is being done about this further issue, so we don't, because I know how onerous it is for the parties to start re-arguing the case after it's finished, and we want to keep it within bounds.
It needs to be clearly defined. Yes.
Good. Thank you very much. Yes, Ms. Coulter.
I'm grateful. I would certainly endorse that submission. That any further submissions are going to have to be very carefully defined. And on this particular issue, we're currently left in, and it may be that I simply have to live with it for the purposes of this appeal, a highly unsatisfactory situation in which the edges of my learned friend's case on contractual interpretation are blurring. It is now being said that there are communications that go from a counterparty to a fraudster which are not in breach of clause 14, despite the width of the interpretation for which my learned friend has until, as of 5 minutes ago, contended. And if those edges are sort of lost, I have 2 points about that. One, that it is unsatisfactory that we are now in the dark as to precisely which communications in the passage of to and fro that we have been concerned with are in breach of clause 15 and which are said not to be in breach of clause 15. Secondly, in losing the edges of that wide interpretation to escape the trap, as it were, of the circularity issue, this forces my learned friend to adopt a different interpretation, which at present is undefined and completely, at least to me, unclear. But in my submission, that really rather goes to my primary point, which is that the wide interpretation is wrong and that the narrow interpretation is right. But certainly on the logic of my learned friend's case to date, the email which he now says is not a breach has always been logically a breach. So this is a change in addressing my lord's point. My learned friend's case is necessarily having to change and shift in a way that is very unclear. And what would be deeply undesirable in my submission is if another interpretation, narrower but not as narrow as mine, is sort of here in a nebulous form and then developed in written submissions after the appeal. My learned friend made his election on what clause 14 means for the purposes of this appeal, and in my submission he should be bound by that.
Well, the email itself is a document hereunder.
Yes. And it contains information on my learned friend's case as to the width of the clause. It's difficult to understand. I mean, I quite understand that my learned friend is not arguing the point now, but on his interpretation of clause 14, an email being sent, and we'll try and find some examples of exactly when this has been said in pretty much exactly these terms, the to and fro is in breach of clause 14. And I had certainly rather understood that to be the premise of the appeal, because if that's not right, then one starts to look at which are and which aren't in a different way, which at the moment at least my learned friend is not explored. He just says this one isn't, for reasons that in my submission are not actually explained.
Well, I do think we understand that what was put to us this morning was that document and information must be read literally, and anything that is produced thereafter hereunder is caught by confidentiality. So we do understand that
Yes.
that is a change of position. It to some extent highlights the rather strange case which is being advanced, that a confidentiality clause covers any document, no matter how mundane.
Yes. Yes. And until now that has suited Logix to run that, in my submission, unsustainable argument, but it suited them to run it. And now it doesn't. But it hasn't changed in my submission in a way that is susceptible of any sort of principled analysis. It's just shifted to take this one out of the net. Moving on, this morning I took the position that on the point about whether or not the 4 emails from my client are disclosures within the meaning of clause 14 was not open to me on my respondent's notice. Having read it again, and may I say for the probably millionth time over lunch, I think that I'm probably wrong about that. And that's not ideal, I appreciate, but I think I'm probably wrong about that, because ground 3 of the respondent's notice is widely expressed. What it says is the appellant has no real prospect of establishing that the wider interpretation of the confidentiality clause is correct. And I do go on to talk about commercially sensitive information and the significance of that wording for the interpretation of the clause. But going to the judgment, paragraph 101, which is core bundle 7, tab 7, page 87. And this is, of course, where the judge addressed this point. The judge is treating this as part of the wide interpretation, so the claimant's interpretation, that a disclosure doesn't have to be intentional or deliberate is in fact part of that wider interpretation. And in my submission, which I entirely appreciate my learned friend may want to deal with in reply, I can revive the point that we're right to say that these are not disclosures within the meaning of clause 14 either, for the same reasons as I submitted at first instance, namely that they are inadvertent disclosures to a fraudster in circumstances where the fraud is ongoing, and that looking again at clause 14, that it will not disclose such information and documentation to any third party, carries with it a degree of deliberation as to the disclosure of that information and documentation, which does not capture the scenario here, where the disclosures are taking place in the context of an ongoing fraud, where the parties are entirely unaware that the fraud is happening.
I have difficulty with this inadvertent characterisation, whether it's advertent or inadvertent. what we're talking about here, in fact, is whether it's involuntary. Take a situation ridiculous as it is, where somebody discloses information at gunpoint. Some third person comes in and, for reasons of their own, get somebody to give out information that's commercially sensitive, at threat to their life, and then disappears. I mean, where does that fall? That's clearly involuntary. What you were both doing in this case was involuntary. Had you known what you were doing, you would have stopped it.
Yes.
Would have been the judge's finding about that. So I don't think inadvertency, which has to me a different connotation of something just having, as it were, slipped through. I mean, what's happening is you're doing something that you actually do not wish to do, but you're only doing it because you don't realise that you're doing it. It's inadvertency doesn't capture it, to my mind. But anyhow, that's
it's also not quite what one would classically think of as inadvertency, because subjectively, each party believes that they're not disclosing to a third party. They believe that they are disclosing within the confidentiality personnel.
Yes, they believe they're doing precisely as they ought to do. When we've used the word unwitting to try to capture an element of what you may be describing, and it is what is so distinctive here about what is being alleged against my client.
It's not. I mean, one can think of many adjectives that are far more suitable. Unwitting may be one of them. Manipulated may be another.
Well, they're simply deceived. They're simply deceived. They believe they are dealing with their counterparty at all times and in respect of all of these communications. Which, on this disclosure idea, it just simply doesn't fit at all with what the purpose of clause 14 and what clause 14 is intended to prevent against, which is letting information go where it should be protected for the purposes of the deal. And in my submission, it doesn't anticipate, and its purpose is not to protect in respect of this kind of fraud. My learned friend says that it is, although that case is very unclearly in my submission not pleaded. But certainly on my submission, that is part of why the disclosure point comes back in on ground 3 and on what I say about that interpretation simply being far too wide. If I may pick up also, just again, the terms of the amended particulars of claim. I'm using the copy in the supplemental bundle at tab 4. And just to pick up a quick point, what I said this morning about paragraphs 4, 19 and 20, this is the false negligence point. I wanted to pick up 2 points. First, that is not an issue in respect of the pleadings that could be cured by amendment, and also that it is addressed by the judge briefly in paragraph 44 of the judgment. So that is tab 7, page 72. Where she refers to paragraph 4 retaining text from the original pleading that was apparently relied upon, she says, to support the claim that was then advanced in tort. So it was to present these two parallel duties, one in contract and one in tort. And she says then the pleading does not go on to identify any alleged failures on the part of the defendant to take such reasonable steps, and the allegation in paragraph 4 was not relied upon as part of my learned friend's submissions on the alleged breach of the confidentiality clause. And in my submission, that remains the position. It's not a provision in the pleadings that is relied upon on this appeal, and it cannot, in my submission, be revived.
I don't think clause 4 is suggesting a tortious duty. It's a proper construction.
Yes.
And then clause 19 was a alleging an implied term. So I think both of those are alleged as contractual terms.
Yes, so the clause 4 promotes a construction of the confidentiality clause, which I don't understand to be pursued, and which in my submission is obviously wrong. And that would mean contractually you're bound by that under clause 14. And then they also put forward a very similar tortious and contractual duty, either as what 19 said was an implied term rather than simply an interpretation of clause 4. They say in paragraph 19, which is now deleted, that it would be implied as a term of the letter of intent or in tort. So it seems to suggest something other than paragraph 4, but they seem to have the same effect.
This sort of brings us back to what is clause 14 all about. Are you coming on to that? The purpose of clause 14.
Yes, I dealt with it briefly this morning, but I will be coming back to it. But it's an important point, as I understand it. That's clause 4, paragraph 4, forgive me, of the amended particulars. It is not being suggested on the appeal that Siam Aero was in breach of that clause and failed to take all reasonable steps to protect information and documentation, as I had understood it, but perhaps it is. But you then have a question of reasonable steps and what reasonable steps are. I can deal with it perhaps in this way. Our understanding of their interpretation of the clause has been for this appeal that anything that is disclosed, that is given away to the fraudster, is automatically a breach, without the requirement of that being a failure to take all reasonable steps. Because, of course, if one talks about reasonable steps, you get into precisely the circumstances in which these counterparties are sending information to the fraudsters because they've been deceived and they don't know that they're doing it. But it is...
All that we know in relation to the origins of this is that somehow or other,
yes,
the 29th of July email, or possibly earlier emails, came into the possession of the fraudster.
yes.
And that may not have been through hacking a system. It may be that somebody forwarded an email to somebody or left one lying, a hard copy lying somewhere they shouldn't have done.
Yes.
So I'm not sure that we're even in the territory of any of this, are we?
No. I hope we're not. I hope we're not, my lord. But there was a mention this morning that there is a pleaded case, I think it was said, in respect of negligence or failures to take care by my client. I don't understand that to form any part of the appeal, and perhaps it doesn't. And in which case one completely ignores paragraph 4 of the amended particulars. I will proceed on the basis that is the position. Now, in paragraph 26.4 of my learned friend's skeleton, so that's core bundle tab 2, page 23. There is a suggestion at subparagraph 26.4 that this is submission in respect of our statement of reasons for refusal of permission. They go on to say the breach of the confidentiality clause was plainly a fault. If that is wrong and negligence is required, Siam Aero were negligent. They ought to have seen the change in Logix's email address, and the particulars of claim can be amended appropriately. Again, in my submission, this should form no part of the appeal. There's no evidence before the court of negligence on behalf of my client. even if there were, in this respect, they ought to have seen the change in Logix's email address. That certainly would rebound with equal, if not more, force onto Logix. But also, it is not, in the case of my client, negligence that could relate to the fraudster gaining access to the system. So in my submission, it would not, even if pleaded, assist my learned friend's case in any way. Going to, if I may, now the respondent's notice and to ground one, and I'll deal now, if I may, with the first two grounds. It's tab 3, page 29. I haven't dealt yet with ground one and what the focus of this ground is, and it's simply that the appellant did not rely in releasing funds to the fraudster upon the specific nature of information contained in the 4 emails. And we pick up there on the way in which this was sort of sought in quite a vague way to be argued at first instance in paragraph 12.1 of the skeleton there, and that any attempted characterization of these emails as special in some way as to the nature of the information contained in them is unsustainable. Now, my learned friend has put forward a brief proposed further amendment to the amended particulars of claim. I won't dwell on the circumstances in which that's been done. It's been unsatisfactory, but it's best that I simply deal with it. And in my submission, it simply does not assist his position at all. The position is unchanged by anything in that proposed amendment. All that's said is that Logix relied on the contents of the emails as showing that the said emails were genuine documents. Now, that's not, as one can imagine, a case where there is something in there, or which has been disclosed, that is relied on in a very particular way, shifts the dial in terms of an understanding of whether or not they are really dealing with a genuine counterparty. There's nothing here that could possibly differentiate the emails in any way from the many others that go to and forward during the period of the fraud. And in my submission, what's said in this amendment is supportive of the respondent's position. It is simply consistent with the position as we all understand it to be. For the purposes of the appeal and on the accepted facts, parties in the same position equally deceived by a fraudster into communicating with that fraudster in very similar ways. The amendment simply describes what the judge found to be the case, that both sides thought they were dealing at all times with the other. And in passing only, although this goes to a slightly different point, there's no attempt there by way of amendment, either in the last couple of days or at any stage, to identify anything of commercial sensitivity, which also had a causative potency as a result of the commercial sensitivity. And that goes to my ground 4.
Forgive me, just understand. The first question, it seems to me, is on your narrow construction. There would only be a breach if there was a disclosure of commercially sensitive information, and that's assumed for the moment that sending it
Yes.
by email to the fraudster was disclosure.
Yes.
Are you saying that no commercially sensitive information was sent by your clients?
There will be material in the course of the to and fro, which one or other of the parties would doubtless have said is commercially sensitive. So the deal itself, the material in the letter of intent, which has been agreed in the letter of intent to contain at least some material which is commercially sensitive. My Logix, for the purposes of this claim, have never attempted to identify, strikingly, they have never tried to identify what that commercially sensitive information is. But it is, and part of the reason in my submission that would be difficult for them is it would certainly not include the information they seek to rely on in respect of the 4 emails. So, for instance, the idea that sending the bank details, it was in any way enabling of the fraud. The fact that the bank details first, they're not in any way commercially sensitive, they can't be. Also, they're in no way causative of the fraud because they're simply deleted and Vietcombank details are inserted. So the fact they are there is incidental to the fraud, but it is part of the way in which the fraud is carried out. But in terms of what is there that is genuinely commercially sensitive, which is within...
I'm finding this a little bit difficult because it seems to be we're combining concepts rather than taking them. The first question is, do you accept that commercially sensitive information was disclosed? And I think your answer to that is yes. You do accept that commercially sensitive information was disclosed.
In the course of all of the emails or within the 4 emails?
Within the 4 emails.
Within the 4 emails, the SPAs themselves, the parties may say, are commercially sensitive.
What do you say?
Well,
there is an allegation against your clients that they disclose commercially sensitive information. Do you, and you're applying to strike that out, trying to strike out the claim. Are you saying that you did not disclose commercially sensitive information?
I don't think, in fact, they've ever put their case as we've provided commercially sensitive information. They've always put it as you provided confidential
let me rephrase
information.
it. You say that the clause should be construed narrowly as only referring to commercially sensitive information. But that distinction is only going to be relevant if you didn't disclose commercially sensitive information.
Yes.
So do you say that you did not disclose commercially sensitive information?
I don't think that I can accept that we disclosed commercially sensitive information that the fraudster had no access to or didn't have, or that we were the first to do that, because I don't know what the commercially sensitive information is that we're said to have provided. So if, for instance, it's something that was embedded in the link, there's a link embedded in the 29th of July email, which is intercepted by the fraudster. We don't know how, we're not blamed for that. There's missing LRU information there. If it's said that that's the commercially sensitive information, clearly my answer would be no, we didn't disclose that in any meaningful way because the fraudster had it. To take another example, we don't know at the moment exactly when the fraudster got into the system or what he had or she had.
You sent the draft SPA, didn't you?
Yes.
And you sent the signed SPA?
Yes.
And you sent the invoices?
We did send those.
Now, it seems to me it's at least arguable for the purposes of a strikeout that those documents were commercially sensitive or contained commercially sensitive information.
I would accept that, at least arguable.
So that's stage one. It seems to me that even on your narrow construction, and assuming that providing them to the fraudster was disclosure, your clients did disclose some commercially sensitive information to the fraudster.
Arguably so.
Yes,
but
arguably
what we
so.
don't accept is that it's causative.
That's the next step.
Yes, and forgive me.
Now you say that that disclosing that information, there has to be something. I mean, first of all, you say in ground one that there has to be something that is relied upon by your clients. Well, I'm not quite sure where reliance comes into it.
This was additional to our reasoning, and it was intended to sort of meet this idea that there might be something causative in that information, because when the appellant received it, it had some particular causative impact. Because I think what was being run as an argument was that they might be able to get home on causation by saying, this was special information, and when we saw it, we knew we must be dealing with you, and that is therefore in some way causative. So the only purpose of this additional ground was to try to close the door against that particular argument, which we understood was being read against.
I thought it was common ground that what happened here was the fraudster inserted themselves. So effectively, he was passing the actual correspondence between the parties, between them, with minor changes, except when it came to the big change for the bank accounts. But so that they were the reason why they were led to believing that they were dealing with the counterparty was they were receiving effectively the emails that they would expect to receive.
Exactly.
So it seems to me that it doesn't matter what the specific content is. It just simply it is the content which each party was expecting in conducting this negotiation.
Yes. That's entirely consistent, if I may say so, my lord, with our primary position on this appeal. So the purpose of the additional ground is simply to close the door against an argument we thought was being run about causation, about the causative impact of these particular emails. Yeah. Because there was this idea or an impression that, certainly at first instance, that there was something special or particular about these 4 emails. And in my submission, there simply isn't on any analysis. And that's a different question, I entirely accept, from whether or not they contain commercially sensitive information. However, if I am right about the narrow interpretation, and there is at least an arguable case that commercially sensitive information was disclosed by my client, as my lord says, the next question is, was there anything causatively relevant in these particular circumstances of those 4 emails and the commercially sensitive information that was in them? And we say absolutely not. They were, for the purposes of how this fraud was carried out, essentially equivalent to all of the to and fro that was going on, all of which was needed to bring the parties, and in particular Logix, to a point where it transferred a large sum of money to the wrong bank.
See, I thought what you were going to run an argument that what the clause 14 is all about is protecting commercially sensitive information from being disclosed so that it might be used competitively against the respective parties, and that this scenario is not what that clause was designed to protect against.
Yes.
And that is why London Joint Stock and Macmillan helps you.
Yes.
Because this is not a situation where the parties have taken on an obligation to protect against fraud. And therefore we are within the primary case, which is the intervention of a fraudster is a novus actus interveniens. And I thought that's where we were going.
I do say that, my lord, and if I didn't say that this morning, I rather thought that I had. I think that the only difference perhaps in the approach is that we rather see that as our secondary case, because our primary case is that the 4 emails were not causative at all. And you only get into talking about London, about the Macmillan case, if there's at least some causative relevance to those 4 emails, such that you then look at the breach, and what the purpose of the underlying contractual duty is.
But are they not relevant? Are they not causative in a but-for sense? I mean, but for the provision of those emails, the fraud would not have proceeded.
They may be causative in a but-for sense, but they're not an effective or dominant cause of the loss. Because we of course say, and we align with the judgment on this, that the cause and the only cause of the loss was the fraud, was the intervention by the fraudster and the subsequent manipulation and deception of the parties. So that's my primary position. That's what the judge found. If one gets to the 4 emails being an effective cause, and the question then is the Macmillan question, we say Macmillan entirely assists us because we were under no duty to protect Siam against what then transpired, i.e. the intervention of the use, I should say, the use by the fraudster of that particular information that we disclosed. It wouldn't be about the intervention of the fraudster, of course, because we're not blamed for that.
I'm not sure whether to what extent this argument has been advanced or was adopted by the judge. Maybe it's just another way of putting it. It seems to me that I think Mr. Page accepted this, that the fraudster becomes involved before there's any allegation of breach of contract on either side. So he's there approaching Mr. Page's client.
Yes.
Now, if and to the extent there is then a disclosure by either side, that disclosure in itself has been induced and brought about by the fraudster as part of the fraud. So it's not a case where you have a breach which then allows the fraud. It's the fraud itself which is producing the breach.
Yes.
Now, is that an argument which features in the judge's judgment, or?
We will check, my lord. I don't think it features in quite that way, but the way we had sought to put it is that the breaches of the clause are an effect of the fraud. So in fact, the arguments about causation are, in a sense, the wrong way up. I think it is implicit, my lord, I have to say, I think it is very much implicit in what the judge found. Because the way in which she describes it is only consistent, in my submission, with precisely the scenario that my lord has just outlined.
It's really the point that the fraud and the fraud alone is the effective dominant cause, because anything else is what the fraud brought about, including any alleged breaches.
Yes.
Well, that, if you're right, would be the end of it, wouldn't it?
Yes. Well, that's our primary case on the appeal, and that in my submission is what the judge found.
So one can approach it in different ways, but your approach is to go straight for causation and go back to interpretation of the clause to see how your case on frustration on causation works with either interpretation of the clause, and you say it works with neither.
Yes.
But one could equally as approach it in the other way and start with the interpretation of the clause and then go on and deal with the causation point.
Yes.
And you say in any case, even if, which you don't accept, your emails were in some way an effective cause, they're not a breach because you weren't under any duty not to do it. And secondly, if you're allowed to argue it, it wasn't a disclosure either, within a proper understanding of what disclosure means.
Yes. And also, Macmillan, if we did breach, then the fraudster's intervention, there's no, we don't, our liability does not continue in the way that it does in Macmillan because we were not under that duty. Now that becomes slightly odd because then we're not in breach anyway.
Yeah. Well, I think we have the main contours of your argument.
I'm grateful. If I may go now. Just checking that I think we've dealt with rather a lot of what I was going to say. So I'm just making sure I'm not going to repeat myself. Yes, in respect of the commercially sensitive point, there is sort of some suggestion this morning that it was said it's hard to imagine what could be more commercially sensitive than that. And there was a reference there to the condition of the plane and to, I think, what was said, life-limited parts, but that wasn't entirely clear. I think that may be a reference to the LRU information, which you will have seen reference to. My learned friend is helpfully nodding. And I'll come on to address the significance of that. But for that purpose, an LRU, as you may know already, is simply a modular component of an aircraft. It's a piece of hardware in the aircraft, and some of the information in respect of the LRUs was missing, as you will have seen, and was then located.
It doesn't matter in the slides. I couldn't quite work it out that the price was higher when they couldn't find the LRUs, and then when they found them, it went down. How does that work?
Maybe there's something wrong with the. I mean, I'm not going to speculate, but I'm not sure that we know.
Well,
or
it
that
really,
formed
it
part
really
of the
doesn't matter,
judgments.
so let's pass on.
One of the many mysteries.
Thank you.
If I may, in respect of the fraudster's intervention, I do submit, and we've just been exploring this, that the proper starting point is the original intervention by the fraudster. And there's of course no suggestion that Mr. Goffstein's email of the 29th of July is a breach of the confidentiality clause, nor could that be suggested. We have looked at some of these documents, but if I may just take the court through the key communications. These are all going to be in the supplemental bundle. So starting at tab 13, page 177. This is one of the unhelpfully, and I do apologise for this, tiny emails. They are tiny. And we did try.
And it's not just my eyesight.
I can't. I
found them impossible to read.
Are you able to? Is it? Yes, I'm very grateful. So this is a genuine email account to genuine email communication from Mr. G to Mr. K, and a moment on the content. We found all the missing LRUs on one of the engines. You can see the certificates and photos on the link. They were installed and lost during the AC teardown. Now we found them, and they're being shipped to the Siam Aero facility, and the hope is they'll be interested in purchasing the engine with all of the LRUs. So what we can see here is that at least some information is embedded into the email which, on Secretariat's analysis, and I think this is more or less common ground, is perhaps the last email that seems to be sent before the fraudster shows himself or herself within the system. That's of course no guide to how long the fraudster had been there. They may have been there for a longer period and biding their time, but this is the point at which the fraudster starts to get involved. Now, the emails from Logix in the French proceedings show what was happening on the other side. And
just before we go through this, what are you showing all this to us for?
If we don't need to.
Well, I don't know whether we need, because I don't know why you're showing them to us.
Well,
what's the point?
In that instance, I think it is important to be aware that the missing LRU information, at least, is in this email, which the fraudster gains access to. So if it's suggested that the LRU information is commercially sensitive and was disclosed by my client.
I thought we just got to the point where you had agreed with my lord that there were some of the things that you sent that were arguably commercially sensitive. So
okay.
If we're on the same ground here, why are we going back over it?
My lord, I will move on. I just want to be sure that there are no documents that perhaps it would assist the court to see, even in the context of the argument that has already taken place. I mean, certainly, my lord, what I was intending to do is evidently not going to be helpful to you, which was to go through the intervention, how it
we're a court
first
of
took
three.
place. But
Would it be helpful to go through these?
That may not be helpful at all.
I think we have them, and we have to take a high level view of all this. I mean, I can't myself see that the issues of principle that we're concerned with are going to change anything, because as we've been told and we agree, the facts are actually quite simple.
Yes. And you have, of course, the table in my skeleton argument where we've sought to put these documents in.
I found helpful.
There is a lot of to and fro, and what it does, of course, bring to life is the way in which the judge, quite rightly in my submission, took these 4 emails and saw them in their true light, and that's her paragraph 99, which my lordships and my ladyship have well on board. I won't then go to the majority of the entries. If I may just momentarily check that there's nothing that you should perhaps see. Two brief points on the facts, if I may, which do go to arguments that we have already explored. The first is that all the way through the to and fro, what the fraudster does is not just take information provided by a party and use it. What the fraudster does is use it in various manipulated ways. So in some places, she or he adds wording to an email that's been sent by another party. In other places, she or he takes the wording out. So the way in which the fraud is carried out is not, as in some cases, that particular items of information are provided that then allows the fraudster to carry out the fraud. It's done in a very different way because the fraudster is, as was explored with my learned friend, inside the system and in between the parties. That's exactly how it happens. There are, of course, also documents that go from Logix to the fraudster, from the fraudster to Siam. It's not just the other way. An example of that are the purchase orders. Right? This is in the table, and it may or may not have sort of risen to the surface. But there are repeated requests from Mr. G for purchase orders so that, he says, an invoice can be issued. And there is therefore genuine versions of the PO request and fake versions of the PO request. And those are referred to in paragraph 23 of the judgments. We probably don't need to go to it. And the result of those requests for the POs are that there is a genuine email from Mr. Lucy of Logix to the fraudster, where he says, thank you for the agreements, will you sign and return? We'll send them to the board. And then Mr. Lucy asks Ms. Kanchun to raise the purchase orders. And that leads to the creation and provision of purchase orders, which is done by Logix and on that side of the line. And that is a good example of it happening on the Logix side of the line and enabling the fraudster to communicate with Siam as though he's Mr. Lucy and move it forward. And it has a characteristic added urgency to it. The fraudster often puts in within today, do it today, when that hasn't been in the original email. And that then leads to the real email, which, if we may just very briefly go to it, this is one or two documents that I will ask you to look at for these purposes. And this is at tab 20, page 331. If I may, and it is of I hope, a more acceptable legibility. You have there at the bottom of the page a fake email from Mr. Lucy. And as you will have seen then from the table, there is at this point a to and fro and a resending of amended purchase agreements because an error has been picked up in the purchase agreement that was originally sent. And fake Mr. Lucy is sending a version of an email from Logix and saying, here are the purchase orders. And real Mr. G at the top of the page says, thanks for the purchase orders. Please find the signed agreements with the correct legal entity. Looking forward to receiving them countersigned. Also, we will send you the invoices tomorrow. So the invoices are triggered by the purchase orders, and the purchase orders were requested by Siam but sent by Logix. All of this happens via the fraudster. And this is the email relied on at 12AB of the amended particulars. So here we see that the amended purchase agreements are actually corrected and sent back by Logix and then sent on. And I've made my point about the purchase order, the purchase orders, and then of course then the invoices. I think that's the only one that I specifically would wish to take the court to. And this is the factual matrix that in my submission the judge, respectful submission, precisely understood. And it's a matrix very specific to this fraud, but one reflective of a fact pattern which will be common to many email interception frauds. And of course, therefore, what we say is that when one sees the mechanism of this fraud and the way in which the fraud utilises the multiple alleged disclosures in breach of the confidentiality clause, the suggestion then that there are 4 particular emails that one can pick out and say are causative is in my submission, hopeless.
Yes.
You have my submissions on chain of causation and narrow interpretation. Dealt with those already. Briefly, if I may, just in my skeleton argument at paragraphs 27 and 28, so that's tab 4, page 44 to 45.
Can I make another suggestion to see what the only thing that the fraudster does with any information is provided with is to give it to the party to whom it was intended to go. They're not making any use of the information other than to send it to its intended recipient. The fraud doesn't depend in any way on receiving confidential information. The information that in the emails may all be entirely anodyne. All the fraud depends upon is inserting oneself as a go-between, so that the key point you can insert, you give information, namely you, the fraudster, give information, namely your bank account details. So the fraud is not in any way concerned with the use of confidential information or obtaining confidential information. It's concerned with putting yourself in a position to give information deceptively to the victim.
I would accept that, my lord. It's another way, perhaps, of articulating the incidental to the fraud point in respect of causation. And it is partly why the right and principled interpretation is my primary case on this appeal, and the judges, consistently with the judges' findings, that it is the actions of the fraudster in intervening and then manipulating which is the cause, and that the confusion comes when one tries to pick out these emails as though there's something about them that is causally significant to the fraud when there isn't.
Yes.
We have dealt with. I was going to, of course, go to the authorities and the new authorities, but I think, in fact, the court has been taken to the key paragraphs that my learned friend relies on, and I will try and therefore take that quite quickly. We probably don't need to go back to them all. You have my submissions already on London Joint Stock Bank. The judge in my submission was right to rely on the passages that she did. But of course, what the judge was doing was she was distinguishing London Joint Stock Bank from our situation. The other purpose and use that I seek to make of London Joint Stock Bank is that if I'm wrong on the primary case, London Joint Stock Bank assists me. It clarifies, as does the passage in McGregor to which you were taken or went, at paragraph 9209 of that text, that the point is this is an exception. It's perpetrated in circumstances where the contractual duty is to take care the act doesn't happen, and that is not our case. The new, so you have my submissions also on why it was the judge was right to make the distinctions that she did. And the distinctions that she made are, of course, highly relevant to the point on duty. The judge went about it in a rather different way. She looked at it and said, this is a very narrow duty in respect of the making out of the check, and that's not the same as this. And I accept and adopt that. But there does, in my submission, need to be a further emphasis on the nature of the duty. Now, on acts of Logix intervening acts of the claimant, there are a couple of new authorities referred to here, but they really simply relate to the passages in McGregor that are relied on in respect of intervening acts, and this question of recklessness or whether they were unreasonable. That, in my submissions, you have my chain of causation submissions, and I don't need to make those again. The only point I should make is that neither Borealis nor County or the County case can, and the Stacey motorhome case can assist my learned friend, because none of these authorities fit this case. The Heskell and Continental Express case is authority for the simple proposition that a wrongdoer can't excuse himself by pointing to another cause. It's enough that the tort is a cause. It's the same point for the nth time. The alleged cause does need to be a cause, and our case simply is that the 4 emails did not cause the loss. So one never reaches the effective cause stage. So in conclusion on the law, if I may, the judge accepted rightly that this wasn't a case about third-party intervention, including a fraudster, or about the intervening acts of claimants, and that in the particular factual circumstances, those authorities did not and do not assist. This is not a case, and we have explored this already, where there's any suggestion that the defendant has allowed the fraudster in. That was the case that Logix originally tried to plead and abandoned. Remoteness, I don't need to address. And you have my submissions already on the principle, but just a few words only on the implications. Of course, this has had serious implications for my clients. You will be aware from the judgment that the claim has been used for the basis for interim relief in France, and the engines have been subject to seizure. But there's also quite a profound and concerning implication for counterparties who are deceived and who are the victims of a fraud like this, if they can be, as my learned friend suggests, then treated as the cause of the loss.
Yes, I think we covered this morning, didn't we?
By way of conclusion only, my lord, but those are my submissions unless I can assist further.
No. Well, thank you very much, Ms. Coulter. Enjoy your last few days in the second row. Congratulations.
Like the second row. Thank you so much.
And congratulations.
Thank you very much. Thank you.
I've just got a few very quick points on reply. Ms. Coulter said that no commercially sensitive information was identified in the 4 emails. However, they were pleaded as as containing confidential information. It's just a pleading point and rather a weak one, and I think that was dealt with by, from recollection, my Lord Justice Phillips in argument with her. The judgment at paragraph 103, Ms. Coulter says there's that the SPAs and invoices weren't any cause at all. Well, in my submission, that's completely wrong. But I'm not going to enlarge on it because you've heard enough from me about that this morning. Ms. Coulter said that there's no pleaded duty not to provide material to a fraudster, but the particulars of claim paragraph 3, and I don't think we need to take it up. The amended particulars of claim, original amended particulars of claim, states that the parties contemplated in entering into the LOI that there was a danger that confidential information could be used by a fraudster in this way. Ms. Coulter said that I was completely changing my case and saying for the first time that not all communications between the parties were a breach of the confidentiality agreement. However, I distinctly recall this morning, in answer to a question, I think from my lady, that there would be that not absolutely all communications were a breach. I remember saying if a communication was just inviting somebody to a meeting,
yes,
that wouldn't necessarily be a breach. So it's not a completely new point. It's consistent with what I said this morning.
Why wouldn't it be a document hereunder?
Sorry?
Why wouldn't it be a document hereunder?
Well, I accepted an email is a document, but I would have thought that the parties can't have intended things that documents that contain no information at all to be breaches.
It does contain information. And
Just asking for something.
what it demonstrates is that you do accept that one has to look at the contents of the document to decide whether it has some quality which must be protected as confidential.
Yes, but I think the class of documents that aren't covered by this would be pretty small. It's only documents that really don't say anything at all.
But I thought you were, forgive me, I thought there you were taking a very literal, asking us to have a very literal reading. You say A refers to commercially sensitive, but we're not dealing with that. We're looking at B,
yes.
And that refers to 2 things, information and documents,
Yes.
hereunder. So read the words, if it's information or it's a document hereunder, then it mustn't be disclosed. And that, I thought, was your very strict reading of the clause.
Yes, my lord, but I did qualify this morning by saying that there may be some communications that are not covered.
Yes. Well, I don't mean to be an intervener in this case, but I'd understood the complaint that you were having to meet, if you wish to do so, was not whether you said something this morning, but what your case has been. And the objection that is being taken is that, faced with difficulties in your case, you then moved your ground. So you start with all, not just confidential, and then you say all but ... So you then say that things like "hope you had a good weekend" isn't covered. But even "hope you had a good weekend" might be commercially sensitive to a third party. It shows that they're having a negotiation and they're getting on. So, I mean, the point that's being made to you is that you're opening a third possibility, that it isn't narrow, it isn't broad and all-encompassing. it's something in the middle.
Yes, but the only thing I query about that is that if I changed my position, it wasn't trying to deal with a problem that had arisen in
I wasn't expressing a view myself. I was trying to be Ms. Coulter's mouthpiece by
Yes.
By saying what I understood her to be saying, which was that you were changing your position to escape difficulty.
I wasn't changing my position to escape anything. I was just trying to be sensible, because it seemed to be that the parties couldn't intend a completely anodyne message, which didn't say anything of any importance to be covered. But
Well, it shows that they're negotiating over the sale of aircraft engine. I mean, who knows whether that's commercially sensitive or not? It might be to their closest competitors. You know, it's not self-evident, it seems to me. Anyway, that's the point.
I think I've said all I sensibly can about that. Ms. Coulter is taking a point on whether an inadvertent, or I think the other word used was unwitting, disclosure is a breach. But the judge at first instance found that it was, and there's nothing in the respondent's notice about that. So in my submission, that's a point that she can't take.
Well, if a bank manager on his way home inadvertently leaves your bank statement on the bus, that's a gross breach of confidence.
Yes.
Even though he's done it inadvertently. I don't really see how one can say that inadvertent disclosure isn't a breach of a confidentiality clause.
Well, it's not my point, my lord.
No, I'm just saying
Yeah.
I agree.
Yeah, thank you. I'm very grateful for that. Yes, so Ms. Coulter talked a lot about paragraph 4 of the amended particulars of claim, which was there. Maybe it should have been deleted, but so I'm sure your lordship understands when this case started and the particulars of claim was served, we had no idea how the fraudster had obtained all of this information, and we thought that one possibility was that Siam had been hacked, and it turned out they hadn't been. They had a report from an independent company that shows that they haven't. That's what clause that paragraph 4 was all about. I'm reminded from behind that, as well as the LRUs, I'm sorry I've called them LLPs, line replaceable units. In addition to them, the things like the price and the engine specification in the sale and purchase agreements is very commercially sensitive. And Lord Justice Phillips took a point with which Ms. Coulter agreed, that though the SPAs themselves may have contained confidential and commercially sensitive information, they weren't used as confidential and commercially sensitive information by the fraudster. All he did was alter the bank details, and so the breach didn't cause the loss, as I understand, as I recall the point. However, the breach, we say, was sending the SPAs and invoices to the fraudster. Whatever use he put to them, if it caused loss, was a result of the breach. My lords, that's all I have to say by way of reply. Thank your lordships for listening to us.
No, well, thank you, Mr. Page, and those who support you.
Before we said that before your lordships and my lady rose, we needed to deal with the exact scope.
Yes. Well, firstly, can I just check that neither my lady nor my lord has any other points to explore with you? No. So what is your intention?
My intention is by 4 o'clock on Tuesday to supply any further points, and any. I think I'm allowed any argument in relation to the points that have already been made in relation to the circularity point.
Right. So we're ring fencing this
Yes.
in relation to the possibility ventilated by my lord
Yes.
this morning that that as a result of this being induced by a fraudster, that it's there's a circularity in the breach argument.
That's the only thing on which I will be making submissions.
Yes, and
on top of that, I will be giving reference to the authorities which I referred to without being able to give the reference
Yes.
on the question of the common sense approach.
well, if
to
yes,
causation.
don't cut down any more trees for that. If you can send that in electronically with links to the reports, or with electronic versions of the reports, that would be very helpful.
Yes, and the other authorities your lordship asked for were the authorities which I know there are.
Yes.
About this kind of email fraud.
All right. Well,
They
thank you for undertaking that, Ms. Coulter. Any comment on that, or when would you like to make any responsive comment if you feel it's called for?
May I just briefly check behind me? I was going to suggest 4 o'clock on the Thursday, but if I may just check.
You read my mind.
Is that what you thought?
Thank you.
I'm in course on Wednesday, so that wouldn't be ideal, but Thursday should be fine.
All right,
May I just check with my
Yes,
instructors?
thank you.
That's convenient to my team if it's convenient to the court.
Response by 4 p.m. on Thursday.
Great.
All right. Can we just inquire? There hasn't been any live note of this. Is it your intention to have a transcript of this hearing or not? Just as a matter of.
I'm sure we will want to obtain one.
Could we then just ask you? I'm not putting you on the spot about this, but if it is intention of either of the parties to obtain a transcript for their own purposes, could they be good enough to share it with the court?
Of course.
And also to do what they can to get it prepared expeditiously.
Yes, of course.
Yes.
So, yeah. All right. Well, thank you, as I say, not just advocates, but all very much interesting case, and we'll take time to think about it. You will be well aware of the procedure. You'll receive handed down draft judgments. Please help us by identifying any factual errors, editorial corrections that needed, typographical, that sort of thing, and please scrupulously observe the warning at the head of the order, which is that disclosure is to take place only to those who are on the list of permitted disclosees, and disclosure in this case has a very extended meaning. Once you've had the opportunity of doing that, please agree an order that reflects our decision and attempt to agree all incidental matters between you. If you can't do that, then very short written submissions will be the basis upon which we'll dispose of those. And the judgments will be published in the normal way on the National Archive and Bailey at a date of which you'll be notified. Thank you all very much indeed.